Hello and welcome to Your Hometown Solutions. I'm your host, Jean Newell with Waterview Realty. And here in the studios, every week we talk to experts that help you make decisions concerning your family, your home, your finances, your dog, your cat, your garage, your garden, just about anything that concerns you and you need an expert's advice. They're here in the studios with me every week. And today we're going to be talking about the law. And we like that. We want to know more about senior law because there are many concerns and questions that arise as we grow older and approach those sunset years. Where will I live? What will become of me if I'm too frail to take care of myself? Who's going to take care of me and help me make those decisions? How will I be able to pay for long-term care? How will those assets be distributed? In the last decade or so, there's a new category of law that has emerged specializing in helping people answer those questions and learn their rights. It's called elder care or elder law. And in the studios with me today, we have a master of laws.
Very important, very prestigious.
Attorney Alec Prentice, who is an elder law specialist. Welcome to the studios, Elder. I started to say Alec. I'm all right. Maybe I'm going to need some of this care.
Well, good evening, Jean. I think it's been a long day for both of us, but that's what we do. We work hard.
And it's only 1:00 in the afternoon, and I'm making these mistakes, but that's okay. Tell us a little bit about your practice. How did you get into elder law?
Well, basically, Jean, when I was in law school, I enjoyed the transactional courses. I enjoyed the tax courses. I certainly didn't want to sue people for a living. Criminal law didn't seem like the most kosher way to go. I grew up in Florida. There was always a larger elder population around me. I always got along with elderly people. I had a great relationship with both sets of my grandparents. And honestly, I figured I may never get rich, but I'd never go hungry, and I'd enjoy what I would do for a living. Right. So I kind of just fell into it that way.
Well, usually we have John Lack with Lack and Lack Chartered, who owns Waterview Realty and Waterview Title, on with me, and he had a little bit of a conflict today and couldn't make the show, but we would have discussed with you how real estate is evolving and how a lot of the people that we work with now are either selling their homes or needing advice on transitioning into other avenues and other lifestyles. And one of the topics, and we brought it up last week when we were talking to Michelle Taylor from the Fountains, that is an assisted living and a senior living specialist, that there's always those family situations discussing should they stay or should they go. Some people don't know whether they need to go into assisted living. Do they need to stay in their house? And they just need some people to bounce some ideas off of. And that's why they need to go to someone like you that they can look at the total picture and give them some good advice instead of them going to strictly a real estate agent that just might want to sell their house. Maybe that's not going to be the appropriate thing for you.
Yeah.
So, what kind of people do you see coming for your advice? What's their situations?
Well, it ranges, but when it comes to strictly elder law issues, I'm typically dealing with asset protection in regards to getting people qualified for public benefits. And in plain English, that just means they've worked their entire lives to build up a certain nest egg, and if one of the spouses gets sick, we certainly don't want the well spouse at home to go broke, spending $10,000 per month on a nursing home, or maybe, $5,000, $6,000, $7,000 per month on an assisted living facility. So a discipline of law that elder law attorneys engage in is basically asset protection in regards to getting people qualified for Medicaid. It's loosely called Medicaid planning.
Medicaid planning.
Right.
So do you like to see people before they're kind of up against the wall of doing things? Do you feel like you would like to have them come out when they're a certain age, just to kind of get some ideas on what's coming up in the next couple years for them?
Well,
or how do you like to approach that?
To be honest, Jean, most of my clients come to see me in their 50s, 60s, 70s, and they haven't had a real long-term care event yet. Mm-hmm. They're thinking more about their estate planning. In other words, they're wanting to get their wills and their trusts in place and their powers of attorney.
And you do that as well.
And we do all that. Yeah, elder law, encompasses estate planning as well. It's a very important aspect of elder law. And at that point in time, I'll go over, okay, in the future, God forbid, there may be a point in time where you have to go into assisted living or you may have to go into a nursing home. None of us want to talk about that.
Right.
But at this point in time, when you're still healthy, just know that there's elder law attorneys out there that specialize in a discipline of law that can protect your assets, that can protect your nest egg. We don't do here in Florida planning in advance. Basically, people's assets are invested as they deem fit. They have their own financial advisors, and hopefully their financial advisors are giving them good advice, and those assets are building interest. And we want to keep those assets building interest. If their house is moving up in value, we want to keep that house intact, and the house is going to move up in value. If we're getting someone qualified for Medicaid, then I'll let you chime in.
I want you to talk about that because that seems to be the big thing on how most people don't have that kind of money set aside because we're learning that, we're living longer and we're retiring earlier, sometimes forced retirement, sometimes by choice.
Right.
But a lot of people's portfolios disappeared 10 years ago when we had a little bit of a real estate and crunch here, economy crunch, and so what they thought they had in their portfolios aren't there anymore. So we're up to the wire here now, and people want to make some decisions, and they don't have the money. How do you approach that?
Well, in an ironic way, that actually helps someone get qualified for Medicaid. I mean, you get qualified for Medicaid in two distinct ways. Mm-hmm. Either you legitimately qualify. I mean, you're really poor. In other words, you've either lost your wealth due to some extraneous circumstance or you never had any money. I mean, Medicaid was actually put in place by the federal government to pay for the long-term care of poor older people. And us elder law attorneys, we don't think we're abusing the system. We're not getting millionaires qualified for Medicaid. Right. But perhaps someone that's worked all their lives and they have a house, that's worth, maybe 150 to 300 to 400 grand and maybe another 100 grand or so in savings. It could be even a little bit more than that or less. And basically, we know how to basically reposition those assets. So on paper, it looks like they actually beat the income test and the asset test of Medicaid. And we get Medicaid to basically pick up the long-term care tab if they're in a nursing home. If they're in a nursing home, Medicaid will actually pay for the entire bill. So let's say your average cost of a nursing home per month, and the average cost of a nursing home per month in Brevard is around 8 to 10 grand. And we get that person qualified for Medicaid. Well, the private pay bill will stop and Medicaid will kick that money in. Now we lose that person's income, but at least we've protected the assets. Okay. I mean, Medicaid's kind of like, look, or the Social Security code is like, look, you can move through the loopholes and perhaps protect the nest egg, but whatever income is coming in, that's pretty much going to go to the nursing home.
Okay, so if they're only on a fixed income of $1,500 a month, that's it.
That will go to the nursing home, and then Medicaid picks up the difference. It's kind of the two kind of come together to meet the nursing home bill at that point. So
in that particular, they don't leave anything left over for personal expenses or anything like that?
Well, we've moved the money typically to a well spouse at home, and then they don't look at that spouse's assets anymore if we've gotten what we call the sick spouse qualified. If it's a single person, we've repositioned those assets, and they're typically in the hands of the children at that point. So we've preserved the nest egg theoretically, to supplement the applicant's care, but their care is being completely covered at that point by a combination of Medicaid and Medicare. And they've really passed the nest egg on to this, like I said, the well spouse at home, or perhaps their children if they're single. As far as their income, they get to keep $105 and the rest of it goes to the nursing home. If they have any unreimbursed medical expenses, they're allowed to keep money every month to pay those as well.
Wow. those are some of the things. So what would you advise people to do? Is it prudent to start looking into elder care insurance or just investment planning? Like you said, maybe some elder care planning. But one thing before we talk about that, it just hit me when you were talking about nursing home. Do you also step in as a elder law specialist when there's any kind of elder abuse at some of these nursing homes and so forth?
No, that's another discipline of law, and that basically amounts to what we would call some type of tortious interference, and that would be a matter of malpractice for a torts attorney.
Okay, so you would know where to refer them off.
I refer those cases out. We're basically doing asset protection.
Okay.
And then during the course of asset protection, of course, we kind of also have to act as the nursing home patient's advocate too, because we're basically maneuvering through a very dense and complex system, and there's a ton of people involved, and the facility's telling them one thing and their friends are telling them another. So we're doing the asset protection, but we're also that source of stability that they can always call during the course of the qualification period and say, what do I really believe? And hopefully the attorney knows the law and knows what to say. Or if they don't, they'll research and find out the answers.
I know a person, this is a little slightly off topic, but I'm not too sure if this even kind of qualifies for what we're talking about. But they were young. He was in his 50s and he had a stroke. So he ended up with dementia where they could not have him live by himself or with his wife. And they put him in, since he was so young, and they knew he was going to be at this assisted living facility, and I think it was really more of a nursing home,
right.
Assisted living. And the only way he could qualify for Medicaid, his wife, would have to sell everything that she had.
Was this in Florida?
This in Florida. Yeah. So she had to divorce him so he could qualify for Medicaid. Have you heard of things like that?
You hear of these horror stories, and basically they were given bad advice. The facility doesn't really want a whole lot of Medicaid qualified people. They would rather have that private pay money.
Right.
So if someone goes into a nursing facility and they're private paying at the tune of $8 to $10,000 a month, the last thing a nursing facility is going to say, hey, you know what? You can really, save money if you go to attorney Alec Prentice, down the street, and he'll get you qualified for Medicaid. And then our monthly money goes from $8 to $10,000 to $5,000.
Right.
So yeah. And what they'll do is oftentimes the facilities will tell people they have to sell their house, which you don't. In Florida, your house is what we call an exempt asset. So in other words, to keep it simple, if you're a single person and you want to get qualified for Medicaid, you can only have $2,000 in total countable assets. And to keep that simple, let's just think of a checking account with $2,000 in it. So you could have a checking account with $2,000 in it, and you can have a house worth up to $560,000. It's your homestead residence, and you qualify for Medicaid. The nursing home, what they will sometimes do, and I'm not saying that they all do this, they'll say, go ahead and sell that sucker, sell that house. Then once that house is sold and we have liquidity, it's no longer exempt.
Right.
So now we have $562,000 that we have to deal with. And of course, the facility wants to spend that down, at the tune of $8 to $10,000 per month, on average. If they know about elder law attorneys, we can even take that liquidity at that point and reposition it. It's much easier if you leave the house intact, obviously, because it's just exempt as is. Even if you're in the nursing home, it's still considered an exempt asset because it's your homestead. And Florida and federal law looks at it as, even though you're not living there, you always have the intent to return, no matter how far along you are in regards to dementia.
You've been listening to the advice from a master of laws. I love that title, Estate Planning and Elder Law Care. Advice, Alec K. Prentice, attorney at law at 7630 North Wickham Road in Melbourne. And you have a website. Let's go ahead and give that out because people might want to just go on there and peruse that information.
You can peruse my website. It's very easy. It's just PrenticeLaw.com.
Spell Prentice.
Prentice, P as in Paul, R-E-N, T as in Tom, I-C-E, law.com.
Good, and you spelled correctly. You spelled it correctly.
Well, hopefully after 8 years of...
You'd be surprised at the people that spell their names wrong on the show. That's wonderful. So how would one find an elder law specialist? Of course, you're getting advice from Alec, but is there certain criteria that you would advise people? Maybe they're listening in another area, another state, and so forth. You only specialize in Florida, is that right? Or just Brevard County or other counties?
In Florida, but, as far as Medicaid planning, it's such a dense area of the law. Typically, attorneys don't go outside of their county. As far as other things that we do, like probates and, estate planning, that can be anywhere in Florida. But from a pragmatic standpoint, I serve Brevard County. Every now and again, I get some clients outside of Brevard County, but it's not too often.
Well, when I interrupted you, I think we were going to get ready to talk about estate planning, I believe is where we were going with that.
Okay.
Tell us a little bit about what you would advise people on estate planning. Exactly what does that mean?
Okay. Estate planning basically, in my estimation, entails moving your assets to your loved ones in the most time and cost-effective manner possible. Okay, that's fundamental estate planning. I mean, estate planning can get a lot more complicated than that if we're dealing with the very wealthy. Right now, each and every person has a $5.5 million estate tax exemption. And if you're married, you can double that up. So we're not doing a whole lot of estate tax planning for people in Brevard County anymore. That knocks most of us out. I know it certainly knocks me out. I mean, I'm only 43, but I'm not a multimillionaire yet.
I know that's a pretty big figure.
Right. And it's adjusted every year for inflation. And especially if you're married, you double that up. So you're looking at 11 million.
Mm-hmm. So let's kind of get a typical scenario. You've got someone maybe coming in at 50 years old, and they want to talk about not only their own estate planning, but maybe they also want to talk about their elder parents, and they want to get advice for both generations. What do you like to start with? You want to look at their portfolios, their income, have a budget? Where do you start with?
Honestly, we start with just general figures first. I like to look at what the assets are and how much they're worth, because initially I just have to know if I'm dealing with a taxable estate. And back in the day when I first started, when the estate tax threshold was much lower, around $1 million.
Yeah, I can remember that. Wasn't that many years ago? It doesn't seem.
Right. We had to do a lot more trust work in regards to estate tax planning. Now, I just to be prudent, and so I don't commit malpractice, I still kind of have to get the values of what you have.
We don't want you to do that.
Right. And sometimes people are a little, wary of exclaiming, how much they have. They may think that you're going to charge pursuant to that. And I try to say, look, I'm not trying to be nosy, but this is for whether, this is knowledge I need to have in regards to whether I need to do tax planning for you, or at least tell you that you may have to do it, whether you do it with me or somebody else. And that typically loosens them up. But since tax planning typically isn't what we're doing a whole lot of these days, we're looking at probate avoidance. Okay. And probate's not a tax. Some people think that it is. But that's basically the circuit court process whereby your assets are moved through the circuit court, and the circuit court judge makes sure that the retitling of your assets actually happen according to the language of your last will and testament. Okay. And because it's a circuit court process, there's lots of statutes and lots of rules that need to be abided by, and that creates a lot of work for the attorney. So if we're probating, a relatively larger estate, it's good money for the attorney. We get 3% of the gross, which can be a pretty high number. A lot of people want to avoid that, and I don't blame them. It also can be time consuming too. Probate can be from anywhere from 6 months to a year. Yeah. It can drag on for longer than that. So a lot of my clients, they're interested in avoiding that. And I don't blame them. I mean, if probates land on my lap and I didn't do the planning, it's good money for me. I love it, whatever. It's part of what I do. I know how to do it. My clients come to see me early. I tell them all the mechanisms, and there's some very simple mechanisms they can use to avoid probate. We typically use a combination of a simple will, pay on death and transfer on death beneficiary designations, and sometimes we use what's called a revocable living trust.
Let's talk about that second one. You said a simple will, and what was the other one?
They're called pay on death or transfer on death beneficiary designations. In Florida, we've made it real easy, and I'm sure other states have too, but you can go to your, let's say you have a $50,000 mutual fund at, I don't want to name a bank, a local bank.
Right.
And
the First National Bank.
Right. And you want that mutual fund to avoid probate upon your death. And again, let's take the example where you're a single person.
Right.
You can go in there and sign a beneficiary form naming your 3 kids to get that asset in equal shares. It's called moving an asset by operation of contract. And when you die, your kids just show up at the bank with your death certificate and they cut 3 checks.
Bing, bang, boom.
Bang, 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 boom. If that would have had to have flowed through your will otherwise, and it would have had to go through the whole circuit court procedure of probate.
I'm not sure my mother had that, but I know she had some kind of a trust that she had set up,
right,
where everything, the very next, I think it was within 24 hours, just everything reverted to me and didn't have to go through probate or anything, cars, everything. Would that, you think that was
It was probably what we call revocable living trusts. Some people know them as living trusts. Some people just simply know them as trusts. For all intents and purposes, they all mean the same thing. Mm-hmm. I mean, there's all sorts of different kinds of trusts that we don't have to get into this evening. But as far as the main trust that elderly people talk about and think that they want, it's the revocable living trust. And it's simply called that because you can revoke it at any time. You can amend it at any time.
Do you want to stay on the friendly side of your parents?
Of course, yes.
All the time for not only those reasons.
You don't want them thinking they're moving their assets into something that they've lost control over. I heard your last segment. Yeah, the elderly people don't like losing their independence, and that's just how it is. And I know I'm going to be the same way with my personality.
When you start getting rid of cars and houses and their independence, they don't like that. They want, as you said, they want to feel like they're still in control of their life. So being able to do this up front, at least they know that they've been in control of that particular situation. So we have the simple will, we have the revocable trust, and we have the
beneficiary
designation.
And oftentimes using a combination of 2 of those things, sometimes all 3, you can completely eliminate probate. I mean, if you have a revocable living trust in place, that can cause absolute probate avoidance. It's basically this intangible entity, this contract, if you will, that you sign, and you move your assets into it while you're alive, and you still completely own those assets while you're living, except after you've died, you've kind of contracted with someone that we call a successor trustee. They're basically the executor of the trust. Mm-hmm. And when you die, they have instant fiduciary access to all the assets that you've moved into this thing outside of the circuit court's reach. So they can immediately start contacting all your banks and whatnot, liquidating all these things. They can get your taxes paid and then distribute the remainder to the loved ones. The beneficiaries is the technical term. Mm-hmm. And all those assets, again, have avoided the probate process.
Well, on the revocable trust, I have a question here that you brought up. You still have to have a simple will with a revocable trust? You
don't absolutely have to, but every prudent attorney usually drafts what's called a pour-over will. And that's simply a catch-all. Let's say I've done some planning for a 67-year-old gentleman. And we've signed this trust, and we've gotten all of his assets into it, his house, his checking account, savings account, money markets, all of his money assets are in there. And then 5 years later, he walks into a bank and invests $50,000 in a new certificate of deposit, let's say. And he just forgets to put it in his trust. So we thought we got everything in that trust. But now there's this CD that has $50,000 in it that's going to be in his name alone when he dies. So he dies, his will would catch that $50,000 CD or certificate of deposit and then pour it into the trust. And then it would be distributed pursuant to the language that's in the trust. Now, you still don't want that to happen because there's going to be a probate from the will to the trust. So you want to get these trusts properly funded. And there's other estate planning attorneys out there that say, oh, that's why I don't like trusts, because They never get funded properly, and we have a probate going on at the same time as a trust administration. And I've heard that argument, but I can tell you this: a small probate, when most of your assets are in a trust that avoid probate, in my estimation, in my experience, is a lot less invasive than all of your assets going through probate. But again, that's just this attorney's opinion.
What a good attorney, because you are the master of law.
The master of laws in estate planning and elder law.
Tell me how you get that title of masters of law, because that takes extra education.
It's an extra year of law school, and they've been around forever. And typically they were devised for people that practice in taxation or corporations, very dense areas of law. Now estate planning and elder law is getting to be more at the forefront of what society is going through. There's lots of schools now that are actually developing elder law and estate planning LLM programs. And it's an LLM degree. It doesn't have an exact interpretation. It's Latin, but we call it a master of laws.
I like it. It sounds good.
Right.
I always tell people I'm the queen of the world, so
Right.
Masters of Law sounds just as good.
Yeah, it's kind of like backwards. When you're a lawyer, that's kind of like your doctorate, but not really. But you get your doctorate first and then your master's later. Mm-hmm. Whereas everybody else gets their master's first and then they get their doctorate after that if they decide they want to go through more torture.
So you do a lot of speaking in the area and helping the community understand a lot of these different ideas and so forth. If someone wanted to just get a general idea of what's going on, do you have a package? Do you have some kind of a price range that if they come in and they speak to you for an hour and that you can do a simple will and so forth and it's X amount of dollars? Do you have something that available? Because a lot of people are thinking, it's going to cost me $10,000 to get his advice.
First of all, most of my consultations, the initial consultation is free, especially if it's involving estate planning, guardianship, probate. Because basically people, they come in, they have an issue, they give me a set of facts, I loosely apply those facts to the law, and I tell them whether I can help them or not. And then I quote basically usually a flat fee according to how in-depth I think the case is going to be. And then we kind of contract from there. And they don't have to obviously decide on the spot. I give them a contract. They can take it home, throw it away, or they can take it home, think about it, and bring it back. With long-term care, oftentimes I will charge for those because I'm asked very pointed, direct questions that are subjecting me to liability. So I'm engaging in a very serious area of practice just by giving this consultation. So sometimes I do charge for those. And I'll tell people in the beginning of the consultation or on the phone, they're told ahead of time that a long-term care consultation could be free. If it starts getting into more dense areas, the attorney will let you know the free has probably just converted to a pay. You don't have to move on if you don't want to.
Mm-hmm. Well, I think that's great because people, again, sometimes people are afraid to reach out and get this information because they put it off because they think it's going to be too expensive or someone's going to talk me into something I'm not too sure I want. That's why we search out for the experts that have that teacher's heart. I like Dave Ramsey. He's always talking about find the expert with a teacher's heart that wants to educate the public on what's available and not the salesman's heart. So we are here to help you make those decisions at your Hometown Solutions. We only have about a little over a minute left. Okay. Alec, tell us a little bit more about what you could share with the community as far as advice right now that they might need to know as far as where they are in their estate planning and so forth. If they have nothing, is that the good time to come see you?
Yeah, I mean, initially, when you start moving through your 50s and into your 60s, you at least should have your wills in place, your durable powers of attorney in place, your healthcare surrogates in place, and perhaps your living wills. That's your fundamental estate package. So your wills, okay, if you haven't done any further planning, you may not be escaping probate, but at least you have some instrument that explains to the world where you want your stuff going.
Exactly.
That's not such a bad thing. Your power of attorney will allow your named fiduciaries therein to handle your finances if you lack capacity, thereby enabling you to escape guardianship. A healthcare surrogate allows the people named therein to talk to doctors for you if you ever lack capacity. And of course, I think we all know what a living will. We sometimes call it the Terry Schiavo document. It's like, look, if basically I'm hooked up to machines and you've done all you can, it's okay to take me off.
Wow, lots of good information. Alec, Prentice, thank you for joining us today on Your Hometown Solutions. Give out your website one more time.
It's PrenticeLaw.com.
PrenticeLaw.com. Thank you for joining me today with Alec Prentice, Masters of Law, Attorney at Law, Masters of the Law. I love it. And join us next week. We have another exciting guest that helps you make all of those decisions on your family, your finance, your home, your garden, your garage, all of those things, because we're here to solve your problems at Your Hometown Solutions. Thanks, everyone. Bye-bye.